and I represent more than 30 accusers of Bill Cosby, including Judy Hutt. We have a civil lawsuit on behalf of Judy Hutt against Mr. Cosby, in which she alleges that she was 15 years old when she became the victim of sexual misconduct by Mr. Cosby at the Playboy Mansion. The reason that I am here today and was present at the preliminary hearing is that I am monitoring all legal proceedings and developments involving Mr. Cosby. And that was my purpose today.
Can you give us your take on what Mr. Cosby's defense was in this case today?
Well, Mr. Cosby presented a vigorous defense today. I might add that in my experience, 40 years of practicing law, I found it to be very unusual that such a defense was presented at the preliminary hearing stage in the way that it was. One would have to speculate why. You know, some might speculate because the defense was attempting to have an impact on the potential jury pool to suggest that no crime was committed. Having said that, I believe it's also an advantage to the prosecution to be able to hear from the defense the potential themes that the defense may present at the trial. The defense suggested that they felt that Andre Constant should testify. Just to be clear, I don't represent Andre Constant. I've never had any communication with Andre Constant. They wanted her to testify. They did not get what they wanted. Because under Pennsylvania law, it is not a requirement that the victim herself or himself testify at a preliminary hearing. Of course, she will testify at trial. But under Pennsylvania law, and this is also true in the state of California where I practice and some other jurisdictions, it is not necessary for the victim to testify at a preliminary hearing. Instead, what she has stated in her police report can come in through the interviewing law enforcement officer. In this case, 2 detectives testified about her interview, and the court found that that was sufficient. In addition, this is just my educated guess, I don't think that Mr. Cosby was thrilled that his own interview with the police was admitted into evidence, because some of what he said could be quite damning for Mr. Cosby. Having said that, the court, having reviewed all of the evidence, found that there was sufficient evidence to require the defendant, Mr. Cosby, to stand trial. I think that was the right decision based on the law and based on the facts as provided. I'm happy to answer some questions.
The defense said that she never said no, and then that was part of their defense. Was
part of the defense's argument, in fact a large part, had to do with consent of the victim. The assertion and the argument by the defense that she didn't say no, in other words, therefore that she did consent. The argument of the prosecution is that if a victim is incapacitated for any reason, in this case, perhaps the pills that Mr. Cosby admitted in his police report that he gave to Ms. Constant and her injection time, and the fact that she had not had food, rendered her, according to Ms. Constant, in a state where she was going in and out of consciousness, she was aware that some things were happening. For example, her legs were paralyzed. She could also feel, according to her statement, that Mr. Cosby was touching her breast, touching and inserting his fingers in her genital area, but that she could not say no. She could not say anything, that she was incapacitated. As a matter of law, if a victim is incapacitated, unconscious, or conscious and unconscious and then conscious again, the victim is unable to consent. That's going to be a central issue at the trial as to whether she could consent.
Ms. Allred, do you believe that other alleged victims should be called to testify at trial? Would you encourage any of your clients to do that, to show a pattern?
The question has to do, do I think that other victims will be called at trial? Will any of my clients testify? Under Pennsylvania's prior bad acts legal doctrine, potentially other accusers could be called to testify at trial. Whether they will be called, that is subpoenaed to testify at trial, is a decision that will be made by law enforcement, the district attorney, and the court in terms of admissibility. So that is a decision later on down the line, and that is for the district attorney to decide and the court to decide after hearing what I am certain will be many objections by the defense to the calling of other accusers.
But you believe there's a pattern?
If the testimony of other accusers, one or more, is or could be argued to be a same or similar signature activity, it might be considered relevant and admissible. And so that's for the court to decide as to whether any of my more than 30 clients who are accusers will be called. That's not a decision that is in my hands. That's the decision of law enforcement, and I have no information on that at this time. I think it's probably premature for anyone to be making that decision.
Ms. Allred, I touched on this, but how damaging was Mr. Cosby's words themselves?
I think that Mr. Cosby's interview with the police in the police report that was admitted into evidence was very damaging to him. And it is now in evidence. Often a perpetrator or an alleged perpetrator does not give a statement to the police. He did. And now he's going to have to deal with his own words, which it was indicated through testimony that he signed his statement, that he was asked at the end of the statement something to the effect of, is everything that you have stated in this statement true and correct? And he said yes, and he signed that it was. And then in addition, that he had an opportunity to make any changes, and he did not. Now, the defense wanted to underscore, emphasize many times that Ms. Constant did make changes in her police statement, suggesting that somehow there is something wrong or inappropriate about making changes. I, for one, am very glad that Ms. Constant, or any person who's alleged to be a victim, has an opportunity to review a police report and make changes to make sure that it is accurate. I've represented many victims in criminal cases and still do, including in rape cases, and still do. And some of them in other jurisdictions have never had an opportunity to review the police report to even see if it's accurate and a reflection of what in fact they told law enforcement. So, of course, in many cases, if a person is lying, then they have a standard script and they have no need to make any changes because they're just going to stick to their script. Often, if they're being truthful, then they want to really look at what is said and make sure that it's accurate. Simple as that.
Ms. Allred, it's a double question for you. That matches sort of a pattern from what your clients have said happened to them.
I think that Mr. Cosby's coming out or something.
Here comes Steele.
All right.
Charlie, here comes Steele.
Ms. Allred, the
Do you have a
defense has
second
already
mic?
made much and will continue to make much of Ms. Constand's continued interactions with and reaching out to Mr. Cosby. What do you say to those folks who do that kind of thing in these kinds of cases as some kind of admission that this couldn't have been so bad, or otherwise why would you continue to interact with it?
I think that only Ms. Constant and her mother should be the ones to explain why there was continued interaction with Mr. Cosby. But there may very well be reasons, and I don't think that one should take that as some kind of a tacit admission that she wanted to continue, a relationship with Mr. Cosby, or that nothing happened of a criminal nature. As a matter of fact, there was testimony about a conversation between the mother and Mr. Cosby. Pardon me?
Can I jump in for a minute?
Oh, I'm sorry. No, absolutely.